Hello! This video is part of a series of resources for Texas commercial property owners. My name is Pat O'Connor, and the topic of this video is, should you sue the appraisal district or file for binding arbitration after the appraisal review board? The short answer is yes. In most cases, you should. Let's talk about the two options and the likely savings. The likely savings are going to be about an additional 10% for commercial properties, so we're not talking small beans here. This adds up and makes a difference. So for the options to file a lawsuit in district court or a judicial appeal, same thing, or one is you can hire an attorney, or secondly, you can hire a tax consultant to coordinate the lawsuit for you. That's how most of the lawsuits are handled. So if you hire an attorney, most attorneys are going to be paid hourly, and they're going to require you to pay the expert witness fee. So there can be substantial upfront cost with no guarantee of results. Now, most of the time, there will be results, but they may or may not be enough to support the cost you incurred. Now, with tax consultants, they mostly take a different approach and do it on some sort of contingency fee, and it varies. Some tax consultants require that the property owner pay the filing fee, which is about $400 a property, and some tax consultants require that the client pay for the expert witness fee. At O'Connor & Associates, we've taken a slightly different approach. We think the right alignment of interest is that we don't get paid unless we save you money. That way, it's a win-win for both of us. So we pay the court filing fee, we pay for your attorney, and we pay for the expert witness. And we do an expert witness report for virtually every case that we take on, both in litigation and in binding arbitration. So you have those two options. The attorneys, and some attorneys will do the work on a contingency fee, and sometimes they pay for the expert report and sometimes they don't pay for the expert report. With a tax consultant, you're more likely to have less downside risk, and with O'Connor, there's no downside risk because you pay nothing unless we reduce your property taxes. So it's really surprising to many owners how powerful the litigation process is, and a lot of our new clients are just amazed that we coordinate so many judicial appeals on behalf of our clients. Our policy is that any property, commercial property that's valued above $750,000 should be strongly considered for a judicial appeal. Now, the deadline to protest is May 31st, and to find out if you're fairly assessed, go to the Texas Fairness Checker at cutmytaxes.com. It's free, requires no personal information, will only take about 1 minute to complete. That's cutmytaxes.com. But in any case, be sure you file a protest each and every year, because the protest process is arbitrary and capricious. When you file the protest, you don't know if you'll be working with an appraiser that's easy to work with or one that's virtually impossible to work with. You only find out if you get a reasonable or unreasonable appraiser at the hearing itself. And so that's a critical reason to file an appeal every year. And finally, the two reasons that the lawsuits in district court and binding arbitration make a lot of sense is it reduces your base value. So if your value had been $2 million and you file a lawsuit and get it down to $1.8 million, when you're negotiating, so first of all, you're saving money. You're saving, in that case, about $5,500. And then secondly, it reduces your base value. So when you're negotiating next time, you're negotiating off a value of $1.8 million and how much of an increase they'll give on $1.8 million versus an increase above $2 million. So keep pressing down that base value each and every year, and that is the key to minimizing your commercial property taxes. Thanks for joining me. Back tomorrow with more tips.